Having witnessed the witnesses and examined the cross-examinations, let us now observe the final arguments by both sides at the oral hearing.
Good day, members of the tribunal and esteemed colleagues. I will now briefly summarize the claimant's case and substantiate the claims advanced on law and fact. I'll first address the respondent's breach of contract, and thereafter I'll proceed to show that the respondent is not entitled to claim the exemption from liability it seeks to rely on in this case. As regards the breach, the tribunal is well aware that the UN Convention on the International Sale of Goods was created to unify international sales law. The convention is divided into 4 parts. Part 1 deals with the scope of application and the general provisions. Part 2 contains the rules governing the formation of contracts for the international sale of goods. Part 3 deals with the substantive rights and obligations of buyer and seller, and Part 4 contains the final clauses. In the present dispute, the applicability of the convention is not an issue. However, the respondent, in its written submissions, referred to Article 3 of the convention, arguing that the contract here between the parties is a contract of services and therefore cannot fall within the scope of Part 1. However, the convention is applicable unless the preponderant part of the obligations of the seller consist of the supply of labor or other services. This is certainly not the case here, given that the preponderant part of the obligations under the contract is the sale of the components of the power plant. Yes, there was subsequent maintenance and servicing of these components, but that was just an additional aspect of the contract, which remains a contract for sale of goods and not services. That said, I now turn to the respondent's breach. As I mentioned, Part 3 of the convention elaborates the obligations of the seller and the buyer. The general obligations of the seller are to deliver the goods and related documents and transfer the property in the goods to the buyer. The convention obliges the seller to deliver goods, as you know, that are of the quantity, the quality, and the description required by the contract, that are contained or packaged in the manner required by the contract, and that are free from any right or claim of any third party. The tribunal will note that the claimant, my client, in this case, met all of those obligations, maintaining the highest standards and performing to the satisfaction of the respondent. In contrast, the general obligations of the buyer are less extensive, and in fact, they're relatively simple. Pursuant to Article 53 of the convention, and I quote here, you can, of course, find the convention in your bundle, the buyer must pay the price for the goods and take delivery of them as required by the contract and this convention, end quote. This article is the counterpart of Article 30, which defines the obligations of the seller. And together, these corresponding obligations are essential for a contract to be a sales contract. At the same time, I stress that although the seller's obligation to deliver the goods corresponds to the buyer's obligation to take delivery, it doesn't necessarily mean that the place and the time of making delivery and taking delivery have to be the same. The respondent cannot argue, although you may hear differently from respondent, they cannot argue that their liability extends only to delivered goods or to the 6 steam generators that were in transit to the power plant. It would, in fact, extend to all goods produced by the claimant for the power plant, irrespective of shipment or delivery on site or otherwise. The obligations mentioned in Article 53 are primary obligations, which are to be fulfilled in the normal performance of the contract. It involves monetary performance by the buyer, in other words, full payment of the contract price as agreed previously by the parties. This has been noted in a number of cases, such as the Oreomycin case. And in the computer, software, and hardware case, it was also stressed that the burden to prove proper payment lies on the buyer. Now, the tribunal has before it the testimony of a number of witnesses who confirm, and you heard it this week, that the claimant did not receive any payments from the respondent in relation to Phase 2 components. And the last payment we received was the final payment for Phase 1 components. Therefore, the respondent is clearly in breach of obligations under Article 53. This brings me to the second limb of my arguments. It's true that a party may be exempted from paying damages by virtue of an impediment beyond its control, pursuant to Article 79(1) of the Convention. However, the standards attached to the condition beyond its control must be stressed at the outset. This exemption is granted only if the impediment is one that the party could not reasonably have been expected to take into account at the time of concluding the contract, and that could in no way have been avoided or overcome. Now, several judicial decisions have clarified that the exemption under Article 79 requires satisfaction of something really in the nature of the impossibility standard. Or you could say it's akin to force majeure, which is a common standard in many domestic legal systems. One well-known example is the Chinese goods case. That's where the manufacturer's dire financial straits were considered not to be an unmanageable risk or an exceptional event warranting the exemption.
Excuse me, Madam Counsel, if I could just interrupt you there, please. Could you tell me where I can find the Chinese goods case? Is it in our bundle here?
Yes, I'm sure it is. Just one second. Thank you. Yes, it's Claimant's Legal Exhibit number 59.
59?
Yes.
Good. Thanks very much. Sorry to interrupt.
I'm not quoting from it, but you can find it at that tab. Now, again, in that case, the tribunal found that even if there were dire financial straits, it wasn't enough to warrant the exemption. And equally, as I said, the impediment must be one that the respondent cannot be expected to overcome. The tribunal may consider how high the expectation is from the party in question. For example, in the tomato concentrate case, the majority of a tomato seller's crop was destroyed by heavy rainfall. Yet the seller was not given the benefit of the exemption because it still had some tomato crop remaining, which it could have diverted to perform the contractual obligations in question. Now, returning to the matter at hand, we see that the alleged impediment is the decision of the government to cancel the contract for construction of the power plant. The tribunal has heard from the respondent's own expert in cross-examination right here the other day that despite the widespread cancellation of contracts, a number of companies managed to negotiate with General Dom and continue their operations. Yet the respondent made no effort whatsoever to negotiate or even recoup its losses by pressing for damages from the Zerasian government. It conveniently just shut shop at the first sign of trouble without caring at all about fulfilling any of its subcontracts. The respondent made no effort to overcome what was a quite overcomable impediment at hand, and thus cannot avail itself of the exemption under Article 79. Now, Article 79(4) also requires the non-performing party to give notice to the other party of the impediment and the effect on its ability to perform. Why? The objective is to ensure that the other party can immediately discontinue performance of its own contractual obligations. But if the notice is not received by that party within a reasonable time after the other side becomes aware of the impediment, then the respondent has to be liable for damages. Here, the testimony of respondent's own senior manager confirms that despite being unsure of the continuation of construction of the power plant as early as November 2012, following the coup, which was in mid-September, the respondent waited and did not bother to inform the claimant. This was despite the fact that the respondent was aware that the agreed completion date for manufacture of Phase 2 components was the end of October 2013. Now, I expect we will hear from my learned colleague across the room that the contract with the Zurasian government was formally canceled only on 10 September 2013. But the fact remains that respondent was aware of the possibility, indeed the probability, of this happening several months before, and was obliged to give due notice to the claimant, who could then have reevaluated its manufacturing schedule and, for example, slowed down. A failure to give that notice disentitles respondent from claiming protection under Article 79. Now, the seller's remedies for the buyer's breach of contract are set forth in connection with the obligations of the buyer. If the required conditions are fulfilled, the aggrieved party may require performance of the other party's obligations or claim damages or avoid the contract. Now, since the respondent has exited its power plant, performance of the contract is no longer an option. So the proper remedy in this case has to be payment of damages, those being for respondent's failure to pay the price of the Phase 2 components. In our written submissions, the claimant has detailed the quantification of damages consistent with the principle in Article 74 of the Convention. The Tribunal has heard many experts testify this week in this regard. In the interest of time, I'm not going to make further oral submissions regarding the same, but merely recite and repeat the claims for the convenience of the tribunal. In sum, the claimant requests the tribunal to adjudge that it is entitled to the following. First, payment of the outstanding sum of $60 million towards manufacture of the components for Phase 2 of the power plant project. 2, damages for losses suffered due to premature termination of maintenance services with respect to both phases of the project in the amount of $20 million. 3, costs of the arbitration and legal costs and expenses. And 4, finally, any other relief that the tribunal sees fit to provide to the claimant. I thank you, members of the tribunal, for your patient hearing. The claimant rests.
Thank you, counsel. And now it's time to hear from counsel for the respondent.
A very good day to members of the tribunal and to my colleagues present here. I will now present closing arguments on behalf of the respondent, Electro ACE Incorporated. The focal point of my arguments will be the respondent's entitlement to exemption to liability under Article 79(1) of the Convention. I shall establish that the conditions for invoking the exemption did exist, and that the respondent acted responsibly and within the bounds of the law, despite being in a difficult position in Zurasia. Before addressing Article 79, however, allow me to address the issue of breach of contract itself in response to the claimant's argument on Article 53 of the Convention. The respondent is not bound to pay the claimant the price of the components for Phase 2, as the time for payment has not yet arisen. The respondent cannot be held liable to compensate the claimant if the claimant was ahead of the agreed schedule for manufacture and delivery. As the tribunal is well aware, Article 53 deals with two obligations of the buyer. First, the buyer must pay the price. This may indeed be described as the main obligation. Secondly, the buyer must take delivery of the goods. At the same time, Article 53 specifies that these obligations are to be discharged as required by the contract and this convention. The significance of this phrase is its explicit statement of the central and unitary role of the contract. The convention itself does not contain extensive provisions on the obligations of the buyer. This is because in most cases, the important issues relating to the price and its payment are almost invariably dealt with in the contract. In relation to payment of the price to the seller, three aspects arise: what the buyer shall pay, where he shall pay, and when he shall pay. In the present case, there is certainly no doubt about the former two aspects, the what and the where. However, clarity is absent with respect to the when. Neither the contract nor the convention required payment to be made to the respondent when the contract was terminated. The contract requires the respondent to pay a total of US $120 million for the components supplied, and a further US $4 million yearly for the next 5 years for the servicing. The contract specifies that payment for the components is to be made in two equal tranches, corresponding to the two phases in which the power plant was being built. Each tranche was to consist of a lump sum of US $60 million as full and final payment for components for that particular phase, payable when supply of all the components was complete. This is in fact verified by the conduct of the parties with respect to supply and payment for phase 1 of the plant. The claimant delivered all components required for phase 1 and thereafter received the payment of US $60 million from the respondent. As regards phase 2, the testimony of the claimant's senior manager confirms that the claimant planned to manufacture phase 2 components separately from those of phase 1, and only after phase 1 was completed. Thus, phase 2 components should have been in the process of being manufactured at the time this dispute arose. However, the facts show that 6 steam generators were to reach Zorasia by 21st September 2013. This shows that the claimant was well ahead of its production and delivery schedule. The respondent cannot be asked to compensate the claimant for its enthusiasm and alacrity in manufacturing components. The provisions of the Convention support this view. Article 58 deals with the time for payment. The basic rule is that goods are exchanged for payment of the price. The buyer is not required to pay until he receives the goods or documents controlling their disposition. Moreover, Article 58.3 states that the buyer is not bound to pay the price until he has had an opportunity to examine the goods. In sum, the respondent has not breached its obligations under Article 53 of the Convention and cannot be held liable for damages to the claimant for the entire cost of the components for Phase 2. Without prejudice to the argument on breach, the respondent shall now establish that it is entitled to the exemption under Article 79 of the Convention. Article 79(1) of the Convention reads, "A party is not liable for failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences." The crucial element is the impediment, and it is here that the respondent disagrees with the claimant that there is a need to meet an impossibility standard. On the contrary, the respondent submits that the standard to be met is that of hardship. Such an interpretation is consistent with the theme of reasonableness that colors the entire Convention. The tribunal may consider the approach of courts and other tribunals to this provision, and I've included the relevant cases in our bundle of legal exhibits.
Counsel, do you have any specific case in mind?
Specifically, the respondent would highlight the decision in the butter case, in which the buyer could not accept delivery of the butter as the Customs Department of St. Petersburg prohibited the entry of the goods due to the high content of lead salts. The tribunal rejected the seller's argument that the buyer could have attempted to negotiate with the officials for the release, and found that the state's refusal to permit importation of the goods was a sufficient impediment to allow exemption. The tribunal will note the butter case's similarity to the present dispute. The coup by General Dom and the subsequent cancellation of the state's contract with the respondent to construct the power plant was in effect an impediment which struck at the root of the respondent's contract with the claimant. In fact, one could argue that even the stringent impossibility standard is satisfied because the components supplied by the claimant would have no application, there no longer being a phase 2 to install them in. The tribunal has already heard the testimony of one of Zurasia's foremost political commentators, confirming that there was simply no scope for doing business with the new dictatorial regime in Zurasia. The political theatre in Zurasia was not something that was in the respondent's control. No reasonable business person could be expected to have foreseen, much less taken into account, such a sudden change in regime in what had theretofore always been a model democracy. Such a change was even less conceivable at the time of the conclusion of the contract, because the power-starved country was desperately looking to expand its domestic power sector and as rapidly as possible. Finally, there was no way for the impediment itself to have been avoided or overcome. Negotiations with General Dom had proven futile. His writ ran large, and the respondent was only one of many foreign investors who faced trouble. The one or two exceptions that managed to somehow negotiate their stay in Zurasia certainly do not make the rule. In these circumstances, the respondents submit that it is entitled to the exemption under Article 79(1) and should not have to pay damages to the claimants. I will spare you further elaboration on our submissions relating to the quantification of damages, except to state that they are without prejudice to the argument on exemption. I thank the tribunal for its time and patient hearing. But before I end, I would like to briefly point out the respondent's counterclaim on the defective Phase 1 components supplied to it by the claimant. Our written submissions and our expert witness statement are self-explanatory and comprehensive on this claim. So I shall not speak further on this issue except to say we are at the tribunal's disposal should there be any queries or clarifications needed. With that, the respondents rest.
Thank you, counsel. Now, do either of my co-arbitrators have any questions of either counsel?
I do not, Mr. Chairman.
I do not. I too have no questions. Now, I understand that counsel for both parties have conferred with each other and have agreed that no post-hearing submissions need be filed, having regard to the fullness of the evidence and arguments that have been presented at this hearing. Now, is my understanding correct?
On behalf of the respondents, yes.
For the claimant, yes.
Thank you. On that basis, that both parties have already made a full presentation of their respective evidence and submissions, and subject to any questions the tribunal may wish to put to the parties subsequently, the tribunal now declares the proceedings closed pursuant to Rule 28.1 of the SIAC rules. So it only remains for me to thank both counsel for the cooperative and efficient way in which they have handled this particular arbitration, and of course thanks to our transcriber for her efficient and willing assistance. We will now retire and deliberate, and you will receive an award from us in due course.
Thank you all. 감사합니다.
Thank you very much, and we wish you all a good weekend ahead.
The tribunal now declares the proceedings closed, being satisfied that the parties have no further relevant and material evidence to produce or submissions to make. The submissions phase concludes, and it is now up to the arbitrators to deliberate and then draft the award.